Hey guys, this is John Watts. Thanks for watching this video. This is a follow-up to a video we did a few weeks ago, or maybe a month or so ago, where the CFPB had sued Encore and Midland Funding, Midland Credit Management, those types of companies. Well, now they have proposed a settlement with these companies, and the judge will have to decide whether to accept that or not. But here's what the Consumer Financial Protection Bureau is proposing. I think it's pretty weak. Okay, but this is what they have come up with Midland and Midland Funding, Midland Credit Management, Asset Acceptance, and all of those companies are really under the Encore umbrella. So we won't look at this entire document, but we'll just look at a few things here. So they filed suit back September 8th, 2020. And for some reason, I can't highlight stuff on this. So I'll just try to use the pointer here. And so we come down to the findings. The defendants are not admitting anything. They're not denying anything. They're only admitting facts that give the court power or jurisdiction over this. And then we have some definitions. And I'll put a link to this so you can read it yourself. There's only a couple things that are interesting. We have what a debt is, and this would be basically the definition in the FDCPA. So we have a video, one of our very first videos on the whole series of FDCPA statutes that defines what various words mean. And so this would be similar, if not the same. You can see the defendants. We've got Encore Capital, we've got Midland Funding, Midland Credit Management, Asset Acceptance. And then we have what legal collection is. So in some states, I think in Florida this is true, that Midland has their own internal lawyers that work for Midland that file. Now, we don't have that in Alabama. So we have a couple different law firms that file. But this is saying whether it's an internal legal department or a third-party law firm, if they are collecting a debt, sending letters on firm letterhead, filing lawsuits, then that is all legal collection. But it does not include post-judgment collection. So if they get a judgment, what they do after that is not considered legal collection as defined here. And then this is an interesting thing. The original account level documentation, you'll see this abbreviation OALD. And if you read this, these are all options. So they can just do any of these. So any documentation that a creditor provided to a consumer about a debt. That's pretty weak. Okay. I mean, that could be one letter, one statement. This is more substantial, a complete transactional history of a debt. But again, it's just or. And then it's copy of judgment. Okay. And then time-barred debt means a debt that's beyond the applicable statute of limitations for a debt collection lawsuit. And that will depend by each state. And so what they are doing is, I want you to think about it this way. It's like they catch the bank robber, right? Remember, they sued back in, 2015? CFPB sued all these companies. So now they sue them again in 2020. It's like, hey, you're back robbing banks. And so here's the settlement. They go, promise us that for 5 years, you won't rob any more banks. And Encore, Midland Funding, Midland Capital, they're like, okay, for 5 years, we won't rob any more banks. Okay, you really got a fantastic settlement out of us there. That's what they're doing. So we've got, here's some things that there's a few things of substance here. They won't initiate a legal collection lawsuit unless they have that original account level documentation. So it's got to be the consumer's name, last 4 digits of account number, the claimed amount. If it's higher than the charge-off balance, they have to explain how that is. If they're suing under breach of contract, they have to have the contractual terms and conditions. I do want you to think about that. I mean, I think they have to have this anyway. But now we have them agreeing to this. So if you're fighting them in court and they're suing you for a breach of contract and they do not have the terms and conditions of your contract. Remember, a credit card agreement is just a contract. So how do we know what the interest rate is? How do we know what the late fee charge is? How do we know what the grace period is? How do we know what the over limit charge is? Well, we look at the contract. Those are going to be the terms and conditions. Well, this says they better have those contractual terms and conditions applicable to the debt. So we've had them come in, they sue us, and they say, well, here are the terms and conditions from 2020. Well, half this debt was supposedly incurred in 2017. What are the terms and conditions for 2017? They go, well, we don't know. We got them for 2020, and I'm sure they're pretty much the same. And my response is, being pretty sure that they're pretty much the same, that ain't the standard in court. You need to show what the actual terms and conditions are. So this can actually be helpful. Again, I think this is part of the law anyway, but now you have Midland agreeing to this. So that is useful. Chronological listing of all names of prior owners. Any one of the following: a document signed by the consumer, very rarely will have that, or original account level documentation reflecting a purchase, a payment, or any actual use. So again, that can be one statement. So this is not particularly helpful, okay? And then they say, look, you can't engage in legal collection without providing the consumer certain information about the debt. So name a creditor at time of charge-off. Well, again, they kind of have to do that anyway under the law. Last four digits of the account number. Again, this is what they would normally do. So Midland's just agreeing to what the law already is. This is not particularly noteworthy. Charge-off balance, how you calculate any amount in excess of the charge-off balance. And this part is interesting, this Roman numeral V or number 5 here. A statement that upon defendant's receipt of written request, so not oral, not verbal over the phone, it's got to be written, the consumer will be provided copies of documentation referenced in subsection A. So just go back, see what they said. For any disclosure, they must inform the consumer to provide the documentation within 30 days and at no cost, but then they only have to do that once a year. And then, for 5 years after the effective date, they will not collect or attempt to collect any time-barred debt through litigation or arbitration. Well, again, that's fabulous. So wonderful that Midland's agreed to that. If they did that, you could sue them. Without this agreement, you can sue them under the FDCPA if they're collecting beyond a time-barred debt. So again, they're not really agreeing to much of anything here. It'd be like me saying, I agree I won't drive 120 miles an hour in a 30 mile an hour speed limit. Well, I'm not supposed to anyway. So this doesn't really do that much. Now, if they're collecting a time-barred debt without doing litigation, here's what they have to tell you. Let's say, look, if the debt's time-barred and cannot be included in a consumer report. So basically, that's about 7.5 years after you stop paying on the debt. So it's too late to sue. It's too late to credit report. Then they have to say, the law limits how long you can be sued on a debt and how long a debt can appear on your credit report. Due to the age of this debt, we will not sue you for it or report payment or non-payment to a credit bureau. But if it's just time-barred, in other words, they can't sue you, but there still is time to credit report, then they have to say the law limits how long you can be sued on a debt because of the age of your debt. We will not sue you for it. So if that's over the telephone, they only have to make that disclosure once every 30 days to you. And they can't do anything that takes away from that. In other words, they can't give you that thing and go, but we can trash your credit. Well, that would sort of contradict what they just said, right? So they've agreed not to do that. And then this other stuff doesn't really matter. Here's the money. So they're paying a whopping $78,000 that I think will go to consumers, okay? And then they are paying, and this is more substantial, but again, it's not very much money. I just did a recent video, I think it was released today, about this article about how they're just making a fortune, these debt collectors, during this pandemic. So, $15 million that they have to pay the Bureau, that's real money. but it's not particularly bothersome to Midland and Encore. It's not going to affect their stock price very much. Their stock may go up because Wall Street goes, oh, really? That's all you had to pay is $15 million? Great. I mean, we've been making a ton of money here. So that's what they're doing. The rest of this is just about sort of the details of how they get the money and all that sort of stuff. So I will put a link to this so you can read this yourself. I think it's pretty unimpressive. Now, there's a couple possibilities. One, the CFPB had a great case and they just sort of folded easy. That could be. Or they might have realized that they really did not have the evidence against Midland Funding, Midland Credit Management, Encore, Asset Acceptance, and so they just took what they can. Hey, that happens sometimes in lawsuits. I don't know which one it is. It's pretty quick. I mean, they filed this, what did we say, September 8th, and here we are October 15th. So what's that, 5 weeks? 5 weeks they've got the case settled. So I don't know. Maybe they did a great job. Maybe they did a lousy job. Maybe they had a great case. Maybe they had a lousy case. But this is what they're proposing. We'll get word exactly what the judge does. I suspect the judge will enter this, will agree to this, and then it will be the final judgment and the whole case will be over. So appreciate you guys watching this, and feel free to subscribe to our channel if you like this type of videos, and we will put out a new video at least once a day. Okay, have a good one. Bye-bye.